Yes, Ms. Kirby.
My lady, good morning. My lords, I appear with Miss Baker on behalf of the father, and Mr. Burden is leading Mr. Sharma on behalf of the mother.
Yes.
My lady, may I start by explaining I'm one of the millions in the country who has the end of a chest infection of some description, and I have got some things to help with that. I hope I'm not going to have any trouble speaking, but just as a
Well, if you need I don't know how long you anticipate your submissions are going to be, but if you need a sort of 10 minutes recovery time, then do tell us, and we'll rise for a few minutes to give you.
Thank you, my lady. I think,
suck on your strepsils.
Yes. Thank you very much, my lady. In terms of the breakdown of today, we're largely obviously in the court's hands. We don't know whether you can go into the afternoon in terms of submissions, and we'll be guided by...
Yes, certainly. Well, if we just deal with a few housekeeping things first of all, but obviously the first thing to say is that nothing must be said which would lead the identification of the children in the case. We are being live streamed, but we have got our panic button. But if we could try very hard to avoid naming the children. I know sometimes it slips out, but let's try hard not to. That's the first thing. The second thing is, may I remind both of you that there is a finding of fact judgment, and you may not go behind it. Miss Kirby, I know that you've tried to dance your way round it in the first 7 or 8 pages of your submissions. We have, of course, read those submissions. But they go perilously close, if not over the line. So if I can just give you that warning, please. And the other thing is that we'd like very much to know what's happening on the ground. So far, where we are today, in a neutral way. We're, of course, not making any judgments, but I'm sure you've each explained to your lay clients, in a family case, the Court of Appeal always want to know exactly what's happening in the children's lives and where they are when we actually get to the date of the hearing of the appeal. So if you could deal with that first. So far as timing is concerned, we have had an opportunity of reading extensively into this case. We've read both judgments, we've read the chronology, we've read the experts' reports, we've read your skeleton arguments. So if we tip into the afternoon, so be it, but we wouldn't anticipate that the whole day is going to be needed.
Well,
I should also say we anticipate reserving our judgment, though again we understand that time is precious, and the parties will be very anxious to have a judgment as quickly as possible. Does that help?
My lady, yes. I was going to start with the update on the ground, as it were.
Excellent, thank you.
My client has, he started psychotherapy after a short delay trying to find a psychiatrist who was also a psychotherapist. They're very rare.
Yes.
He started on the 14th of June with a person with those qualifications,
yes.
A psychiatrist who's a psychotherapist. That psychotherapist had to take a 5-week break, so he lost 5 weeks there. The children had their first unsupervised weekend full day contact on the 1st of October only. So
right. So we've fallen behind. So if otherwise the 26 weeks, if I've done my sums right, would have been actually the 16th of November.
Yes, but now the very earliest, I think 26 weeks could be, and that would mean that the psychotherapist doesn't take any Christmas holidays, would be the 7th of January. But clearly, having taken a 4-week break in the summer, he may be planning to take some more time off over Christmas. So the earliest, the first overnight could be, is the 7th of January.
Mm-hmm. And I don't suppose the parties have done anything like, have any further discussions?
No. And in terms of supervision of contact, the last supervised contact was at the end of September. And as you may have seen, 1 in 4 continued to be supervised by Parent Help, the agency. And the father spent a further 12,000 on supervision of contact between the judgment in May and the end of supervision in September. So the total cost of supervised contact is 75,000.
Mm-hmm. Well, in the context of what they've spent on costs, it's a drop in the ocean, isn't it?
Yes, but obviously a significant addition to the legal costs. As far as the boys are concerned, they are still in the same school.
Right.
And
That's our other question.
yes, and the financial proceedings were arbitrated and finished.
Well, I'm delighted to hear that for the sake of the whole family.
So there isn't, apart from the other point that was dealt with in the judgment was the play therapy. I understand that somebody has been identified. The boys have they were only seeing a counsellor at school, one of them. The other one wasn't seeing anybody, and now I think this far down the line a professional has been identified, but no sessions yet. No, they have. Sorry, two sessions for each of the boys. I think it's
underway.
There might have been three. My client, I think, thinks
It's underway.
It's underway.
That's the main thing. Anything else that we need to know about the position on the ground?
I don't think so. I think that's the.
No, Ms. Vernon, anything else that we need to know?
Only one point, my lady. As a result of the financial proceedings, the family home is being sold. It's subject to contract now. I think completion's on the 31st of October.
Good.
And the mother is moving house to live with her parents. For the moment, as a bridging home, and
Yes.
I think she and the boys are moving within days, maybe next weekend.
Well,
So they're moving home.
good. Well, I mean, anything that moves things forward and gets everyone settled in the next phase of their lives has got to be to everyone's advantage, but particularly the children's.
So, my lady, I agree that's the update, and therefore all contact now is unsupervised.
Right. Okay.
And the issue, perhaps, is therapy.
Well, and when overnight contact would start.
Well, yes, it's a bit bigger than therapy, because the overnight contact is at the moment unusually strictly limited to one overnight
understood.
per week, and obviously that's very different to what the children's expert was suggesting should be happening, i.e. shared care, 50-50.
Well, you've not got permission to appeal on shared care, so Ms. Kirby.
Yes, no, but as far as the order is concerned, the main part of the order is how much time, whatever you call it, how much time the children are to spend with their father.
Understood.
Is a
Understood. So the
most important
outstanding
point.
by the time we've got here, after all, now, all contact is unsupervised. The issues outstanding are when overnight contact starts, which would have been in a few weeks' time, but is delayed by the holiday arrangements of the psychotherapist, and at what stage sequential contact takes place, and not, if I might put it, more conventional holiday contact.
Yes, my lady. The other point, I suppose, to bear in mind, and it goes back to the point of the reserving of judgment, is that the boys repeatedly are asking when are they going to get the letter from the judge that they were told about in May. So Mr. Justice Williams promised that he would write.
Yes, I saw that. He was going to write an appropriate, and that's not happened, has it?
No, it hasn't started. So he had said in the judgment that he was going to write to them,
Yes.
but that he would get input from Elena Sandrini and
Yes.
or Dr. Friedman. That process hasn't started, and the boys are constantly asking for.
Is that your
that
understanding,
letter.
Ms. Vernon, that the boys are still?
It's not my understanding that the boys are constantly asking, but yes, that has not happened. The mother's position is that the boys did ask for a while what was happening, because she explained to them that the learned judge was going to say something, but they've stopped asking.
All right.
recently.
Okay.
But
So, my lady, thank you for confirming what the court has been able to look at so far. Can I draw the court's attention? You will have seen that the fundamental attack that we make at first instance and remains the analysis of Dr. Friedman.
Yes, you've tried to address it as a personality disorder when it's been described as personality traits.
Well, I haven't said that it's a personality disorder.
No.
because
You've attacked it on the basis of the features of a personality disorder.
Yes,
opposed to
because
personality traits.
clearly Dr. Friedman puts it in terms of it doesn't meet the DSM-5.
Yep.
The implication is here are bits of it, but it doesn't quite meet that standard. And that was a key point of attack on Dr. Friedman, some of which, as you know, Mr. Justice Williams accepted. But we say that it is so fundamental to what then happened with Mr. Justice Williams' analysis of the father himself and of the risk that the father presents, that the court needs to look at whether Dr. Friedman can be fundamentally attacked and whether the analysis that Mr. Justice Williams carried out, where he took some parts of it and left others, whether that's actually an acceptable way of going forward. And especially when one looks at Dr. Friedman's report and the way she treats the other two psychiatric reports that were seen by her. You will have seen that the material on which she bases her entire thesis about the father is limited to the fact-finding judgment with its attendant chronology, the two interviews with my client and one interview with the mother. And she specifically says in her report that's all that she looks at. But when you look at the report, she also deals with the two psychiatric reports that were before Mr. Justice Williams at first instance. And they're very short reports, and I do ask the court just briefly to look at them. They're in the supplemental
We've read
bundle.
them. You want us to go to them?
Well, no, if you've read them, but you will have seen then.
Yes,
that
we both read Dr. Allen, which is the unsolicited, the private one that was
Yes.
obtained by the father without court's lead or identification or any letter of instruction.
Yes.
Um,
Yes, that's right. Dr. Allen, he had seen the medical notes only and had an interview with my client but didn't see any court papers. Dr. Oppajic had seen the father, but we say importantly, he saw the father and he diagnosed, and it's in the supplemental bundle at page
obsessive compulsive
4.
disorder.
Well,
And the judge at first instance found as a fact that the father was being honest in what he said to him in the interview.
correct, except that it wasn't an obsessive compulsive disorder, which is an easy trap to fall into, but rather that he had obsessional character traits. Now, one of the attacks that we make on Dr. Friedman is that she says that she mixes up a trait, a personality trait, which we all have, with a problematical personality trait. And what she tries to use Dr. Oppajic's diagnosis to assist her, but it is a diagnosis that has nothing to do with narcissistic personality traits. Nothing to do with. It's a totally different diagnosis.
But often seen hand in hand.
Yes, with narcissistic personality traits, if those exist. And obviously Friedman says that they do, but we say there isn't any evidence of any type of obsession, of narcissistic personality traits. And the evidence that she uses to find that is, amongst other things, this report. But she misuses it because, yes, your ladyship is quite right that she says they often, OCD traits often go hand in hand with narcissistic personality traits, but they are obviously totally different. So when she tries to use Dr. Oppajic as a backup for what she finds, it's simply not there. And then Mr. Justice Williams does the same thing in his judgment. He tries to say that Dr. Oppajic's diagnosis is along the same lines as Dr. Friedman's, and we say that is totally not correct, because what he is saying, the only thing that they have in common, Dr. Friedman and Dr. Oppajic, is they both say that the father needs individual psychotherapy, but they say it's for different things. For my client, it's that he suffers with anxiety and that he has obsessional traits that have become problematical in the family home. And importantly, we say, when you look at the formulation of the problem, it is totally the opposite of what Dr. Friedman says, because at page 4 in the supplemental bundle, Dr. Oppajic says the father is never satisfied with himself. The glass is always half empty, and he suffers from a harsh superego. That is, in my submission, on the opposite end of the scale to a narcissist. And then he obviously he finds that he experiences anxiety and stress, and demonstrates anal retentive character traits. Has an obsession with time management and efficiency. Absolutely no sign of narcissism. And then your ladyship has already mentioned that just seeing the medical notes, Dr. Allen assesses my client in interview and finds nothing of any concern. I pass through him, as it were. His conclusion is on page 13 of the supplemental bundle. But the other document that your ladyship may or may not have had a chance to look at, and that we say is very important in understanding where Dr. Friedman is coming from, is the note of the experts meeting, which is in the supplemental bundle at page 3. It starts at 301. And the reason that at the top of 302, this meeting took place the week before the fact-finding, and JF is Dr. Friedman, ES is Elena Sandrini. And Miss Sandrini points out there that their roles are totally different. She's to look at things from the children's point of view, and how they responded to their parents. And what she found, which you don't find in Mr. Justice Williams' decision, is 5 lines down on the first entry under ES. The children were just as easy with their father as they were with their mother. And she obviously, at the end of that, she says that from my observation, they were very happy and very relaxed with both parents. And then Dr. Friedman asks her, what has changed? Because as the court knows, Dr. Friedman found that there was no change since the fact-finding. And Miss Sandrini finds that there is a significant change. So she starts from the point, they both start from the same point, which is the fact-finding. But Miss Sandrini says, when she's asked what the difference is, well, you know, the passage of time, the children are 2 years older, the amount of time they've now spent with their father, I think they probably all got to know each other a lot better than they did before. Before that, the mother was the primary carer, and the father, even if he was more involved than that which is reported by the mother, the reality is the amount of time they spent with the father was much less. I also think the father wasn't as relaxed in his approach with the children as he has learned to be over time. And that goes back to the issue of the supervised contact and the 800 hours of supervision that he had by the time he saw Miss Sandrini. And then she goes on to say, I got the feeling talking to him as well as going through the notes that actually he took a lot of the comments that were made on board. I think he put them to good use, and he learnt over time. Just a more relaxed dad rather than having this different approach that I think he probably had in the beginning. So she goes on to say, I think it's been a progress. I think she may have meant process. The amount of time he has spent the amount of time he and I spent talking to each other, this is the 4th line down. I got the feeling actually that he responds well, the father that is. I think he responds well on a one-to-one approach. I think he needs time to think and reflect and time to internalize the question and internalize what he's expected to do. I don't think that that his narrative changes. I just think that he's very defensive and defended, and I think he needs that. I can see why he would have been an appalling witness, as the judgment clearly depicts. So she is demonstrating, or trying to demonstrate here with Dr. Friedman, that she has spent many hours with this father and with the mother and with a huge range of people that are recorded in her report. You'll have seen lots of people that the mother nominated, lots of people that the father nominated, some colleagues, some relatives. And in the end, she feels, Miss Sandrini, and tries to explain to Dr. Friedman that he's changed from when the fact-finding judgment it was given in July of 2022. And we do try to emphasise for the court the importance of the timeline, because the first separation for the parents was 2018. The last separation was March of 2021. So by the time they got to the fact-finding hearing, they were already 15 months post-separation. And by the time we got to May of 2023, it was 2 years and 3 months since the separation. So what Miss Sandrini is saying here is the passage of time, the separation, the boys getting to know each other better, Dad learning from the supervision of contact, that there was for her a real change. And then she goes on to explain to Dr. Friedman, and you'll see that it's Miss Sandrini that's doing much of the talking. She says towards the bottom of 303 in the last big passage from Miss Sandrini, I certainly challenged pretty much everything that he was saying to me, and I took him to task about many of the issues, many of the concerns, many of the criticisms and observations made along the way, not just, you know, in your report, but also by the judge and also by Sarah and her parents and so on. And she goes on to give her view that chimes with Dr. Opojic, that the father feels a little inferior, is what she says, which again is the opposite of the grandiosity required for narcissistic personality traits. I think he got really unstuck with Mom and the family, is what she says. I think I would have been, excuse me, it would have been so good if he had actually gone into seeking professional help about how to deal with how he responds to situations earlier on. But anyway, he hasn't. What's important is that he's willing to do that now and in the future. So you may have picked up that the father was saying to everyone that he was willing to do psychotherapy, just not on the basis that he had narcissistic personality traits, as the thesis of Dr. Friedman went. So then you see Friedman
but
says
against
there...
the backdrop of not accepting the findings of fact.
Yes, yes.
And that remains his position.
Yes, yes, my lady. As you'll have seen in Mr. Justice Williams' judgment, I think from the start, the events were all agreed, but the details were not. Mr. Justice Williams made the findings that he did, and my client quite fairly said at the welfare hearing that he still didn't accept the version that Mr. Justice Williams found had happened. So yes, that is the backdrop, but balanced against that is the length of time that has passed since any of the events, and the huge wealth of evidence that the court now had in May of a much more rounded person, a much fuller picture, sorry, not a rounded person, but a much fuller picture of what this father was like outside of those 3 years of the end of the marriage. So again, when you look at personality traits, one of the major issues that we took with Dr. Friedman's report is that for a personality trait to be pathologically notable, it has to be pervasive. And pervasive means it has to be pervasive and long-standing. And Dr. Friedman accepts this in the questions that she was asked, that pervasive means across a number of areas of life, a number of different situations. And what Mr. Justice Williams did not have in this case was evidence of malfunctioning traits anywhere outside of the failing marriage. So if that's right, then Dr. Friedman identifying traits that she says are problematical can't be founded on a medical diagnosis, because it's not pervasive, it's limited to that one area. And what is more significant, we say, is that Dr. Friedman, not only was it not pervasive in other areas, but she had evidence before her of it being the opposite in other areas. So, for example, when she said the father lacks empathy, she says that she based it on what the mother told her. Whereas the issue of empathy, if one does a word search on empathy in the bundle, and you find it in the supplemental bundle, there are a run of reviews of my client as a professional where patients refer to empathy as a standout point that my client has. But when Dr. Friedman was asked about that, and when she saw that, she sidestepped it and said that the important thing was that he lacked empathy in intimate relationships. But that remains just one area of his life, and therefore the personality trait that she identifies is not pervasive in the way that it needs to be. Importantly then, just going back to the experts meeting, Ms. Sandrini asks Dr. Friedman, she says at the top of page 304, one of my concerns about your recommendation is that you're suggesting that he should have 2 years of intensive psychotherapy 2 or 3 times a week. I mean, he's not been diagnosed, he hasn't got a diagnosis. And then Dr. Friedman explains that the personality traits are the diagnosis. And then she goes on again to say, I said that he has traits, but not a full personality disorder. But of course, she couldn't say full personality disorder, because in order to get to the full personality disorder, she had to find 5 traits. And she couldn't, even when she stretches definitions, get to 5 traits in the list of narcissistic personality disorder traits. So what Ms. Sandrini is trying to do here is to understand what Dr. Friedman, and this goes to the question of risk as well, what does Dr. Friedman say is going to be achieved by the father going to psychotherapy? What will change? How will the risk change if he goes to psychotherapy? And at this point in the meeting, Dr. Friedman is saying all contact should remain supervised until he's engaged for 2 years in psychotherapy 2 to 3 times a week. So you can see that by the end of this meeting, she's changed significantly, and it's because Sandrini moves her, shifts her away from 2 years, 2 or 3 times a week.
Dr. Freeman moves her.
Sorry?
You said Sandrini moves her.
Yes. Moves.
Oh, well, they both moved.
They both moved.
Yes, they both move. They both move. But I'm talking here about Friedman's position at the start of the meeting.
Dr. Freeman.
Sorry. Dr. Friedman's position at the start of the meeting is 2 to 3 times a week, 2
And
years.
hers is unsupervised contact, full shared care, immediately. They were poles apart.
Yes.
As experts, they met, and whether neither party probably accepts completely where they came out, but they as experts discussed it and
Yes.
got much nearer an agreed way forward.
Yes,
as they saw it.
but what you may find or think when you see the way the discussion developed is that they each, Dr. Friedman speaks much less than Ms. Sandrini, but there is within this note a real illustration of Ms. Sandrini going through again what is it in the thought process that got her to where she got. And in my submission, what you end up with is that she based herself on a global look at the evidence, whereas Dr. Friedman stopped really at the fact-finding and at her clinical interview in the context of the fact-finding.
He didn't, Ms. Kerr, because his role was, against the backdrop of the findings of fact, to carry out the psychiatric assessment. His role wasn't to go and speak to the sisters, cousins and aunts. That was a really important role for the independent social worker. And then you have to meld them together, those 2 areas of expertise, to see where you come out at the end. So to criticise Dr. Freeman for staying within the scope of her letter of instructions, is that fair?
Well, the criticism of Dr. Friedman is that she adopted way too narrow a scope. She was instructed to see the father with the children, and she decided not to do that, which is why the door was opened to Miss Sandrini at the pre-hearing review in February. And the reason was that at that stage there was no input on behalf or from a child expert. So just going back to your ladyship's question, can you criticise her for what she did? Yes, you can. because what she did was she ignored any evidence that pointed away from the thesis that she first found in the fact-finding judgment, because the idea of narcissism first came from Mr. Justice Williams' fact-finding judgment, and he in a way set that hair running for Dr. Friedman, and she wanted, it seemed, when you look at the narrow focus and the intentional putting to one side the other evidence. For example, she specifically says in her report that she has received the 500 pages of contact notes, which are all positive and covering a span of, I think at that stage, it would have been over a year of supervised contact notes. She doesn't take them into account. She specifically doesn't take them into account. And that,
just give us the reference for that, please.
that's in the main bundle.
Yeah, in the core bundle, in her report, presumably.
Yeah.
Thank you. So just so I can orientate myself when you're
So the
making
report
specific
starts at 118 in the core bundle. Yeah. And
It's just the part where she specifically says she's not going to take the contact notes into account.
not that she says no, she doesn't. She specifically says the only things she's basing herself on are the fact-finding judgment and the two clinical interviews with the father. One.
Bottom 1, 2, 3, is it?
I think it's the last paragraph on 1, 2, 3.
Mm.
Yes, the very end, 1, 2, 3. Thank you, my lord.
Those combined sources.
Of information.
Yep.
So it's these combined sources, and she's just said what they are.
Right, thank you.
So, my lady, the significance, we say, of that is that there is, as I'm sure the court has noted, an unusual level of intervention in the family to have 17 and 19 months of supervised contact. And not just supervised at a contact centre, but supervised by qualified independent social workers that are trained and specialised in looking for difficulties. And these supervisors, post fact-finding, had access to the fact-finding. And we say it's of significance that Kevin Stroud, who was an independent social worker employed by the family from September of 21. September 21. By November of 21, he was saying that, I'll just find the reference for you. His statement is, his second statement in the proceedings is in the supplemental bundle at page 101.
Thank you.
And he supervised contact. It's 102 paragraph 6 is where he talks about the relationship. He supervised starting from September 21, and his last supervision was December 22. He describes the relationship that he saw as the boys never being afraid of their father in his presence, and the father's willingness to learn, etc. He deals with all of that. But what we say is very important is that his notes are given to Dr. Friedman. She says that she's read them. She actually describes some of them it's probably just worth looking at some of the ones that she describes, but then for a reason that we don't understand, she doesn't take them into account. So if we look at in the core bundle at page 134, under the heading, the contact report for the 1st of November 21. So that's only 2 months into his time with the children and 13 months before he stopped supervising. He says, this paragraph under that, Mr. Stroud noted that during the visit, one of the children made comments about Mr. Stroud's involvement with the family. Mr. Stroud said that this was a reminder that the supervision of such time is not a benign activity, will affect family dynamics, and should be kept under constant review. And then on the beginning of the next page, the same visit, it's noted by Dr. Friedman as noteworthy that one of the children commented that Mr. Stroud was there to keep them safe. When the father questioned this, Joshua said his mother said that Mr. Stroud was there to make sure that their dad didn't hurt them. And then at the end of that page, she notes, but again doesn't take into account, the contact report of the 18th of November. Mr. Concluded with the comments from Mr. Stroud about an impasse that he perceived between the parents regarding progression of the arrangements beyond fully supervised time. He said he didn't believe that full supervision continued to be justified, and hoped that progress could be made in the boys' best interests. So that's back in November of 21. After that, you then have months and months and months of independent social workers, Mr. Stroud and others, saying that the relationship is fine, the boys test the father, he reacts appropriately. And for a forensic psychiatrist, adult psychiatrist, to then not put that into the reckoning when she is assessing this father in January of 2023 is, in my submission, improper, because it is clearly relevant, it's forensically notable, and what Ms. Sandrini says in the experts meeting with Dr. Friedman and Mr. Justice Williams picks it up and says that he agrees, that over that sort of period of contact being supervised, it wouldn't be easy, and Ms. Sandrini puts it as it wouldn't be possible to constantly keep up an act. That if you had those problematical traits that Dr. Friedman says, you couldn't keep that act up, because bear in mind, these contact sessions, they're not short. Some of them are for 6-8 hours. So there is a prolonged period. The boys are boisterous. They, Mr. Stroud says at times, are disrespectful, rude, in the way that they had been previously. And Mr. Justice Williams found that the father had reacted improperly and badly. And that was the finding that the court made back in July 22. But here you have lots and lots and lots of professionals saying that there isn't a problem. And Mr. Stroud saying as early as November 21, just as Ms. Sandrini said, supervision is not a benign activity, and it has an effect on the children. And what we say about supervision is that it keeps sending the message to the boys that A, they're not safe, as their mother was telling them in November 21, and that's why supervisors were there. But it also potentially is going to affect them as fathers in the future, and how they parent. It's undermining for one parent to be supervised for this length of time. And for somebody who's supposed to have problematical personality traits, there is no observation of him being rude to any of the supervisors, of thinking he's better than them. On the contrary, the evidence is that he took on board suggestions and improved quickly and consistently. and so that the last year of contact notes, people aren't suggesting things to him. He's able to parent. And that's why we say that the order that was made, supported and founded on Dr. Friedman, is wrong. It's simply wrong. It's disproportionate, and it is at odds with the evidence overall. And when one looks at the weight to be attached to the different experts, Dr. Friedman is given the gold star, as it were, in the judgment. And we say the reason for that is that she went with what the theory was that Mr. Justice Williams put into his fact-finding judgment about personality functioning. And you find that theory in the main judgment, because Mr. Justice Williams himself sets it out in at page 80, paragraph 5 of his judgment. He's quoting from the fact-finding judgment, paragraph 5, and he says, "In my assessment, he has a flaw in his character, which until it is addressed means he poses a risk of losing his temper with them, of imposing unreasonable rules on them, and poses a risk of emotional and physical harm. Until he addresses that flaw, that risk seems likely to remain." So that's Mr. Justice Williams in the fact-finding judgment that Dr. Friedman then bases herself on. And further down that same quote, Mr. Justice Williams says in the last sentence, "How will a psychotherapist truly know if he is engaging or is paying lip service?" So the importance of that, we say, is that Dr. Friedman is clear that her real basis for her examination and clinical assessment is the fact-finding judgment. And within the fact-finding judgment, you will find Mr. Justice Williams' theory of what is wrong with my client and his psychological functioning.
Could I ask, what is the actual finding that you are challenging here? Is it the finding of paragraph 30 of the judgment?
Yes, thank you. Yes, my lord. That finding is based on Dr. Friedman's thesis being correct and well-founded.
So the actual finding is that he has personality traits which are dysfunctional. That's the only finding.
Well, that is the crunch point or the foundation of where everything else
and it seems to me the basis for that is the opinion of a single joint expert psychiatrist, and also there is the opinion of an earlier psychiatrist who expressed the view that he has obsessional character traits. So the difficulty I have at the moment is, for all your forensic picking apart of Dr. Friedman, etc., this is a judge who has made a fairly simple finding which is supported by 2 consultant psychiatrists, one of whom is a jointly instructed expert.
Well,
how can you say the judge was not entitled to reach that finding?
Well, probably need to go back to Dr. Friedman's report and her answers to questions. So if we look at the questions that were asked of her, I think that is actually, sorry, let's start with where she, the questions start at 183, but her report is starting at 118.
In supplementary bundle. These are your lengthy questions, are they?
Yes, it's in the core bundle.
118.
The questions are at 183, but,
Yeah, I
but
have them.
before we get to them, my lady, if I may just...
So you haven't got the questions. 118, bottom right-hand page of the supplementary bundle?
183, there's.
It starts at
183,
118 in the core bundle, but the part that we say is the foundation of where we start to say that Dr. Friedman is wrong, medically wrong, is on page 124.
124.
Oh, the supplementary bundle.
No, sorry,
core
the
bundle.
core bundle, my lord, I'm sorry. I have it, yes, the only thing is the experts meeting at the moment in the supplemental bundle.
It's all right, we've got that.
Yeah.
So 124, you see at the top of the page, We just looked with my lord a few moments ago about the sources that she uses for her thesis, her diagnosis. My opinion is that the father has narcissistic personality traits. This includes manipulative tendencies in relationships, and then she says where she gets that from. Lack of empathy, as described by Mr. Justice Williams in his deceptive attempt to convince his wife. That is, as Mr. Justice Williams recognises, that's a misunderstanding by Dr. Friedman of a fundamental part of the judgment where he finds that it wasn't a put-up job when my client went to Dr. Oppijic. But that's important because it's one of her grounds for saying that he has narcissistic personality traits, is his lack of empathy. And that's the example that he gives. Then inability to handle criticism, lack of intimacy, as suggested by the mother, and sense of entitlement. And she gives the illustration for that of him sitting on a bench near the family home. Now, those are simple examples. One of them is fundamentally wrong. The others are the mother's word for it. They're not based on findings from Mr. Justice Williams' fact-finding. They're just random examples that Dr. Friedman has picked up on. And then she says, and this is what we say is very important, this is not a full set of the criteria required by DSM-5 to diagnose a full NPD. So by implication, we say, she is saying that if I had more, then I would be able to diagnose a personality disorder. And
sorry, Mrs. Kirby, I'm following your train of criticisms, obviously, very clearly. But I'm not quite clear about that part, because we routinely see in psychiatric reports, forensic care proceedings, and childcare proceedings of any type, shape or description, where the psychiatrist will conclude, well, this or that person has certain traits of a particular disorder, but they haven't got the full-blown thing. Usually, in brackets, thank goodness for them, the poor people.
yes.
So it's like you seem to be suggesting Dr. Freeman was trying very hard to get there and not quite getting there. But as far as I read her report at the moment, no doubt you'll help me as to why I'm not right about this. I'm just seeing her having carried out her expert assessment, this is a person who has certain personality traits. They haven't got the full-blown thing, they've just got the personality traits. But having those personality traits has an impact on their day-to-day life, particularly within the family environment.
My lady, that is what she's saying. But I am building towards coming back to why we say that she is using the DSM-5. When Mr. Justice Williams comes to deal with Dr. Friedman, he says, well, there are other standards. You don't have to use DSM-5. But she clearly, in her assessment, used DSM-5 because that's the gold standard, and she says so in her answers to questions. But she says here, when you follow it on, she says that if he goes to psychotherapy, other traits might come out, which by implication might lead to the 5 that you need out of the 9.
Yep.
Yeah, but she hasn't got there yet because you've got to read the next sentence.
Exactly.
Nevertheless,
Yes.
the existence of a number of disturbed traits, not even called anything, such as I've listed above, is sufficient to have caused the father significant difficulties in his life with his family. So that's the key sentence, isn't it?
Well, yes, it's part of the story. She goes on then, possibly his working life is affected. She accepted in cross-examination that wasn't right.
Yes.
But
She only says possibly.
yes, possibly, but it's speculation. But when you then go on to, if we then go on to the questions to Dr. Friedman and go back to the DSM standard, the problem about the traits and the difference between having a trait, like we all have, she's saying that it's so difficult, it's so significant that it has caused problems in family life. But in order for it to be medically significant, it has to be pervasive, which is what we're coming on to now.
All right.
It can't just be in one situation, because when you look at a trait that makes up a disorder, it has to be long-standing and it has to be pervasive.
Take us to that. You've told us that. So take us to the
Yes.
bit
Sorry.
where
So 183.
Right, so we're now into the questions.
Yes, so the question that's asked is
Yes.
what the full set of criteria
Right,
required by
thank you.
DSM-5 is. And she confirms in her answer that the DSM-5 is published by the American Psych at the end of 183, is considered the gold standard for psychiatric diagnosis, which is what she has done. She's diagnosed him. And then she's asked, do you agree that these 9 criteria are
Yeah.
the criteria for NPD?
Yep.
And she says, yes, basically at the end of the list, 5 or more of the criteria are required for an NPD. I totally accept it's a narcissistic personality disorder. What she is doing from her report is using the traits to build towards these criteria and then be short of a disorder, but still suggesting that you're part of the way there or most of the way there.
Well, it's not even that, it's just you've got some of the traits. I don't think it's building to try and get to the disorder. You're saying, if you have this full disorder, these are the traits.
Yes.
These are things that we'll see. But we don't. So he doesn't have the disorder, but of concern is the fact he has certain traits which have impacted on his life.
Yes, but
Now, what's wrong with that, Ms.
what's wrong with it is what comes next. Question 2. Do you agree with the following statement? Everyone has a personality made up of overlapping personality traits. However, to be a disorder, it has to be pervasive, so it goes across environments and functions. Persistent, it doesn't fluctuate over time, and long-standing.
But that's for a disorder.
Yes, but to get to the disorder, you have to have the problematical traits.
No, but if the trait is not pervasive, persistent, or long-standing, then it's not a personality disorder.
Yes, it can't begin to make up the elements that will lead to a diagnosis of disorder.
I don't follow that.
I don't follow that either. I don't see why it has to. I don't see anything there that says a personality trait has to be pervasive.
Well,
One of the reasons it's not a personality disorder is because it's not pervasive.
well, my lady, if you look at the end of the question, if a personality trait is not pervasive, persistent, and long-standing, then it's not a personality disorder.
But she hasn't found a personality disorder.
No, but in order to get to the personality disorder, you have to have 5 out of the 9
but
traits.
she's not got to the personality disorder, and that one of the reasons must be because it's not pervasive across all aspects of his life.
But it's the trait that has to be pervasive, not the disorder.
I know, but isn't the next question very well, if you haven't established a personality disorder, given what you have observed, is that capable of a diagnosis of something other than a personality disorder? And that's not addressed in question 2, is it? And that's what she seems to have found.
Yes. Well, she used traits and characteristics interchangeably, but if we look at the answer that she gives at the end of that question, DSM-5, she quotes, personality traits are enduring patterns of perceiving, relating to, thinking about the environment and oneself that are exhibited in a wide range of social and personal contexts. Only when they're inflexible and maladaptive and cause significant functional impairment or subject distress do they constitute personality disorders.
Does that then move forward into the personality disorder?
Yes.
Yep.
That's the point, is that the traits they can't just be over a 4-year period in your life starting when you're 30, 40, which is what my client was, and then only be in your personal life in a disintegrating marriage, but rather they have to appear across a number of different aspects of your life. And what we had in the evidence that Dr. Friedman didn't take into account, and Mr. Justice Williams didn't, is that my client and this personality issue was confined to that 4-year period in the marriage that led to the fact-finding judgment.
The last sentence says, only when personality traits are inflexible and maladaptive and cause significant functional impairment or subject to stress do they constitute personality disorders. This all seems to be to do with, given what you've observed, does that amount to a personality disorder? does it address the question of, given what you've observed and given your finding that it doesn't amount to personality disorder, is there another diagnostic word that you would use to describe it?
Well, she gives the diagnosis, which is narcissistic personality traits.
Yeah.
That's her diagnosis in her report. So we know what her diagnosis is, and we're trying to understand how she can justify that, given what the DSM says you need to find.
Because I understand that, but where is question 2 saying she can't do that?
It's not.
Not, no, okay. That's helpful, thank you
Obviously, in cross-examination, those issues were grappled with, but not hugely successfly, obviously, from the result. Can I just then...
Can I just pick you up on one thing? You say that the analysis relates to 2017 to 2021, but it also includes up to and including July 22, doesn't it? Because that's when the judge formed his assessment of the father in the witness box.
Yes.
And this report was only written in February 2023.
Yes.
So I'm not sure you can say that in some ways that we've moved on and we're only looking at a 4-year period. We're looking up, but the judge's analysis effectively was the current position when Dr. Freeman was writing her report, wasn't it?
Well, my lord, where I get the 4-year figure from is in the fact-finding judgment that the facts relate to that period, the end of 2017 to 2021. So
Well,
that's where the 4-year period comes from.
The judge's assessment of the father in the witness box.
Yes, but my lord, Mr. Lord Justice Peter Jackson has said that when somebody is being assessed in the witness box, the only thing that the judge can do, we have it in the skeleton, is to decide truth or not of what they're saying, but what they can't do.
What Dr. Friedman is doing is taking into account the judge's assessment of the father, which was July 22. So she is taking into account matters up to July 22.
Yes. Well,
she's doing that in February 2023.
Well, my lord, she is taking into account a combination of things. It's the demeanour in the witness box completely in January 22, but there's a gap in terms of findings sought back to July 22. Yes, but there's a gap back then to March 21, which is when. So in terms of findings of fact, there's a gap
when they
from
separated, after which all contact was supervised. Is that right?
Yes. Yes. So there's a gap in terms of any findings sought between March 21 and July 22. But my lord is right, of course, that the impression the father made in the witness box was in July 22. But then she is looking at my point is, and I'm obviously not making it very clearly, is that when she decides to look at only those 3 sources, the clinical interviews with the parents and the fact-finding judgment, she has made
and her own 2 interviews.
Yes, that's the clinical interviews.
I see.
Yes.
Sorry, yes.
So 2 with the father, 1 with the mother, and the fact-finding judgment.
Yes.
But she doesn't deal with any of the other evidence, and by the time any of the other evidence which contradicts her thesis. So, for example, the empathy point, lack of empathy. She says he showed a lack of empathy. And the example she gives is her misunderstood part of the...
Yeah, we know that, and the judge knew that, so that didn't feature in the judge's assessment. He took that into account when he assessed Dr. Friedman's evidence. He knew that she'd made a mistake, and he says so. So it doesn't really help to say, does it, that she made a mistake, because the judge knew that and factored it in.
Yes, but what Dr. Friedman didn't do was take into account all the evidence from other areas of life, which would suggest that the character trait she was saying, lack of empathy, didn't exist in other areas of life. Yes, sorry.
I think the difficulty I perceive with all of this comes down to this, is that this court is not concerned with reaching a conclusion as to the merits of Dr. Friedman's conclusion. We're not assessing that now. All we are assessing is whether the judge was entitled to come to the conclusion that he did in paragraph 30. And he had Dr. Friedman's evidence, and he assessed it and was aware of some of the defects in it. And he also had the opinion of another psychiatrist. And looking at all that material, he came to a very simple conclusion, which wasn't contradicted by any other psychiatrist, as I understand it, except Dr. Allen's report. But in terms of the weight of the evidence, that the father had these personality traits. At the moment, I'm struggling to see how detailed deconstruction Dr. Friedman reports means that the judge got it wrong.
Well, whereas firstly, I'll move on from Dr. Friedman, but Dr. Friedman excluded evidence in her diagnosis that would have gone against the narcissistic personality traits diagnosis. She excluded it, and therefore excluded information that might have suggested that it wasn't pervasive. When it came to Mr. Justice Williams' job, the job was different. He was to look at, in my submission, the global picture at that stage, and to give appropriate weight to each of the experts. So Dr. Friedman, adult psychiatrist, says what she says, and Mr. Justice Williams finds certain faults with what she's done. But ultimately, he goes with her basic thesis of the personality trait dysfunction.
It was a diagnosis, not a thesis. You
Sorry,
may not agree
yes.
with it, but it was a diagnosis.
Diagnosis of narcissistic, thank you, Melody, personality traits. But what he does is he still, even though he finds fault with it, he then doesn't give appropriate weight to the whole of the rest of the evidence as encapsulated by the other expert who was looking at it from the children's point of view. So,
Well, what you have to say, don't you, is the judge's findings against the weight of the evidence.
yes,
And what he's done is, at the end of the day, he's accepted the conclusion of a single joint expert with expertise in this area. Quite difficult to say that's against the weight of the evidence, isn't it?
well, my lord,
It may be that another judge might have come to a different conclusion. It may be that you say this judge should have come to a different conclusion. But our only question is: was this a conclusion the judge was entitled to come to?
yes, my lord, I know that's the
And
question.
when judges follow the opinion of a joint expert who has twice interviewed the father and followed the judge's findings of fact, how can we possibly say he wasn't entitled to come to that conclusion?
Well, because, my lord, he despite finding fault with her diagnosis and saying that she went too far down the line, Miss Sandrini was also a single joint expert.
But she wasn't a psychiatrist.
No, she wasn't, and she accepts that. You'll see in the experts meeting, she accepts that she couldn't in any way gainsay what Dr. Friedman was saying, and she couldn't say anything against the diagnosis. But by getting Dr. Friedman to look at firstly what Dr. Friedman was saying, which was 2 years more of supervised contact, and Miss Sandrini said, so what will that show us? How will that address the risk? What is the risk? And Dr. Friedman hadn't moved on from the fact-finding judgment and where she got to at the beginning of February 2023, whereas Miss Sandrini had looked at it more globally. And the job for the judge in my submission was to look at all of it together, including Miss Sandrini's view, and to apply the welfare checklist, looking globally at the evidence.
The welfare checklist is a different thing, isn't it?
Because there's two stages. There's two stages,
Yes.
aren't there?
All we're talking about now is whether or not the judge was right to find what, as he did in paragraph 30. I mean, there's a different question as to whether the judge should have made the order he did based upon his finding at paragraph 30. But now, at the moment, as I understand it, we're just addressing, was the judge entitled to come to that finding?
Yes, well, the difficulty always has been the same as it was for Miss Sandrini. To try to challenge psychiatric evidence when you don't have psychiatric evidence is pretty impossible. So
That's what you're doing right now.
Yes, no, I understand.
So can we move on?
Yes, certainly.
So what you're saying, as I understand it, so I think you've dealt very comprehensively with your attack on Dr. Friedman, and we understand that, and I completely see where you're coming from on that. But I think your case is that even if, which open brackets you don't agree, paragraph 30 is correct, and that you can't ultimately succeed in going behind that finding in paragraph 30, you say, notwithstanding that being the case, the judge had another global expert in the form of the independent social worker. And when you factored that against
Yes.
Dr. Freeman, there was still another route that was less draconian and that should have led to a less draconian order.
My lady, absolutely, yes. But not that I want to dwell longer than a couple of sentences in talking about the recommendation of psychotherapy for 2 years. What isn't clear anywhere?
But everyone moved away from that. The judge moved away from that.
Well, he made overnight contact remains today conditional on the psychotherapy
But not for
continuing.
2 years, 2 or 3 times a week.
Well, you'll have seen where we got to was 26 weeks, so 6 months down the line, one overnight for realistically 9 to 12 more months.
Well, that's very different from 3 years, 3 times a week.
Yes, very different. Yes. So yes. In fairness to Dr. Friedman, she shifted significantly by the time she got to giving evidence. But
Well, having been through the experts' meeting, that's what the expert meetings are for.
Yes, and there was, as we've looked at well, didn't quite get to looking at it because it's a very long meeting that they have. But Ms. Sandrini tests the recommendation.
Absolutely.
And the psychotherapy. What isn't clear is what is going to change if the personality trait was confined to that relationship for those 4 years, which on the evidence it appears to have been confined to that. How will psychotherapy change that? How will the risk that the father presents change that? There is no nowhere is that set out. It's not in the judgment, it wasn't in the report, and that's something that Ms. Sandrini seeks to understand from Dr. Friedman in that experts meeting.
I thought that was in paragraph 30 as well. Second sentence, I do find it anew that the father does indeed have personality traits which are dysfunctional. The best way of addressing those and affecting the risks that they carry, and he set out the risks elsewhere, would clearly be in psychotherapy.
My lord, yes, but the risk is the risk in terms of what is it that the court feels is going to happen. You'll have seen that that's something that we say hasn't been properly engaged with.
Got that, but the other argument put against you is that he does set it out in different parts. It's the risk to the boys of emotional abuse and shouting and so on. I'm just paraphrasing. But you said that no, it isn't linked that, and he doesn't say what the risks are in 30. You've got to get that from somewhere else. But he does seem to say there that the best way of addressing the risks, what he has found, as the behaviour being caused by underlying characteristics or traits, that the best way of minimising those risks or addressing those risks is by psychotherapy. That's the link, isn't it?
Yeah, well, it is a link, but the risk. Yes, if you look for the risk somewhere else, we're not clear what the risk is or what the risk of the other alternative. There were 2 possible ways forward. The 2 experts, as you know, were miles apart. One was saying, okay, 3 months before you start the process, and then staged to ultimately shared care. What Mr. Justice Williams didn't do at any time in the judgment is engage with that possibility and
I thought
look
she
at
moved
the
away
risk.
from it by the time it came to court.
Sorry, my lady.
Sorry, I thought the independent social worker had moved away from that initial view by the time it got to court.
Well, when you look at the experts meeting and her evidence, she moved away from saying it should happen immediately.
Right.
She agreed with the 3-month delay
Yes,
before you
yes.
started to remove supervision. But she wasn't asked about what happens after you remove supervision in terms of the different stages that she had outlined in her report. But she said in in the experts meeting, she agreed with Dr. Friedman that it was a goal, that shared care was a goal, but that initially they should start with half and half holidays, and then they could see whether term time half and half worked as well. But she never departed from the ultimate goal of shared care. In my submission, she never left that. She simply wasn't asked to. What she describes, and what I think is very clear in the experts meeting, is that what Dr. Friedman and Ms. Sandrini agreed on is that this should be a final hearing, that the family needed to get out of the court arena, and both of them agreed that the way for that to happen was for there to be an independent monitor who would bring the parents and the children along in the process, so that what she anticipated, what they both anticipated happening, was there would be engagement by the father in psychotherapy. There would be 3 months of, they were saying still supervised, but as you know, Mr. Justice Williams removed the afternoon supervision immediately. And then after the 3 months, an independent monitor would assess, would come and speak to the parents and the children, and then see if it could move on. And that review would be an ongoing process. And they discussed that in some detail, and both agree that's the way forward. You will see that ultimately Mr. Justice Williams didn't want to do that, and instead wanted to keep it in the court arena. He doesn't really explain why he rejected that, which was the idea of both experts at the hearing. And we say that was an error, to keep this family in court, and also to keep, if this family goes back to court in May next year, which will be the next hearing, it's listed for an hour, and at that point it is foreseeable, unfortunately, that there might be further evidence required, because obviously a new order can't be made at a 1 hour hearing in front of a High Court judge. So what is set up for the future is more court, and the legal fees involved in the case, they're all housing money. My client is renting a flat. It's all looking towards another court hearing, possibly another final hearing, maybe another 3-day hearing. It's not in this family's interest. And in terms of the balancing exercise,
That's why asking whether there'd been any more recent discussions.
Yes, I suppose this hearing in the offing hasn't been helpful to that. But that's why when you look at what the experts discussed, what they're talking about is a total lack of trust on both sides. Both mum and dad distrust one another, and they always think the worst of one another. And what Miss Sandrini was suggesting and said she had done in a number of cases was that she would continue to work with the family, that she would take into account what the children wanted, how they were getting on with the previous 3 months, and that she would then assess what the recommendation would be for the next bit and try to bring the parents along in the process. And she explained in the experts meeting to Dr. Friedman how she had been involved in a number of high conflict cases like this, and that process had worked. But they were both clear that they needed to get out of court. So given what the joint expert view was, we say it was wrong to continue it and to have the draconian order that was made. It is an unusually draconian order, and in my submission, given the findings that were made and the global evidence that was there about what happened during the 19 months of supervised contact, there was no justification for continuing to supervise for any period of time. Because when one looks at the risk, Mr. Justice Williams says the wait and see approach is too risky, but he doesn't say why. Because if he had done the exercise of what's the risk, how likely is it to materialize, what are the consequences if it materializes, if against the weight of the last 2 years' evidence of contact, was wrong and the father shouted at the boys, that the harm that would be caused would be not so significant, we say, that it justifies another £12,500 of supervision of contact, which just showed the same thing as the previous 19 months of it, which was good contact, boys happy, boys wanting to spend more time. And again, when looking at the Kevin Stroud notes that are appended to Dr. Friedman's report, you can see that the boys were saying from October 2021 they wanted more time with their dad, and at that time they were having the same time as they're having now.
The difficulty that I'm having at the moment is that the judge has dealt with the individual bits, Miss Andrini and so on, in different paragraphs, and then from 47 he gets to a heading called evaluation. And from 47 onwards he goes through where he's got to, having looked at all the individual bits of the evidence individually, and he makes his findings that the father is not as bad as Dr. Freeman thought and so on, and then he goes through all of the various things. For example, the effect on change at paragraph 50, the harm that might be suffered at 52 and 53, and it's which bits of this on an appeal, as opposed to where we are first instant court hearing the arguments about Miss Sandrini versus Dr. Friedman versus Dr. Opperjick and so on. It's where the judge has gone wrong in the legal sense, as opposed to a different view of that, if you follow me.
Yeah, I do follow, my lord. The where we say he goes wrong is the weight attributed to Dr. Friedman with all her faults versus Dr. Sandrini, Miss Sandrini, with her expertise being in the arena of the children. So what Friedman says, what Dr. Friedman says is, sorry, I've just lost my train of thought there for a second. Yes, Dr. Friedman and her limited microscope looking at what she looked at versus Miss Sandrini looking much more globally and currently at the situation. So if it's right that Dr. Friedman is looking at up to March 21 and the separation, and then, as my lord points out, the demeanour in the witness box in July 22, you will have seen that by the time the father gave evidence again, there was a significant improvement. So that's one thing that is different. But what Miss Sandrini in her report does is she gives the judge a much broader picture of what's going on, firstly for the boys and secondly for the parents. So when she sits down and speaks to the father, she discovers, as my lady says, that he doesn't accept the findings still, but that there are other things that have happened. So he's done an anger management course that was 32 modules or whatever. He's done parenting courses. He's had significant input on his parenting from a variety, especially Kevin Stroud, of independent social workers.
Ms. Kirby, just look at, if we could just look together at paragraph 53 of the judgment. Because that seems to me, arguably, to sort of be a classic example of a judge interweaving the various threads from the various experts.
My lady, it is.
It's the risk has abated. Support the conclusion he's a far better parent now. Accept the point it's been so extensive, it's unlikely his abilities have been all and so on. And that if the risks were very close to service, they'd have observed something and they hadn't. So that would support the conclusion the environment's helped, so on, improvement, so on. But then he says, but given the absence of psychotherapy to address the underlying traits which can become dysfunctional, susceptible to be triggered in times of stress. Now, help me about, and psychotherapy remains the best way of addressing those sources of risk.
Well, my lady.
So what's wrong? Just help me with what's wrong with that as an analysis, given our job as a court of appeal as opposed to a first instance.
What I'm trying to look at is Miss Sandrini has done a global and very comprehensive analysis of where the boys are at. Her evidence is put to one side largely by Mr. Justice Williams when it comes to dealing with the substance of what should happen next. Because what she says is that these are boys who were 9 at the time, they're 9 now, that they...
Next week, I think.
Yes, I think that's right, yes. That they are desperate to spend more time with their father. That all of the evidence that she has seen leads her to believe that that is safe contact and that it should start. Her plan for getting to a much more normal relationship should now start.
Yes, it's clear the children wish to spend more time with their father, considerably more time in the case of LLA. They wish to spend overnights with him. They wish to see the removal of supervision.
Yes,
so there that is in the judge's analysis, loud and clear.
Yes, but when my lady looks at all of the welfare checklist, the wishes and feelings of the boys are loud and clear and consistent over 2 years. Mm-hmm. Very little weight is attached to that by the judge, because in the ultimate order that he makes, the boys are going to see their dad 2 afternoons, the same amount, just unsupervised twice a week for the foreseeable future, up to 9 months is what the judge says if there's no psychotherapy. So their wishes and feelings expressed probably hundreds of times in the papers holds very little weight compared to...
In paragraph 48, he does say this. It is
yes, he
the
does.
Children, and then he says at the end, the views of both boys deserve some weight. They're the views of an 8.5-year-old. They are to be viewed in the context of matters recorded above which lessen their weight, and more importantly, they must be placed alongside the other important considerations, in particular risk and capability.
Yeah.
He seems to do it. You disagree with it?
Well, no, I don't disagree that he says it, but what I'm saying is that in terms of the weight of the evidence, hundreds of times these boys have said, and to Elena Sandrini, they're loud and clear, they want to spend 50-50 is what one of them says. When the order comes out, their wishes and feelings get very little weight compared, and for the reasons that your Lordship has just pointed to, the risk and the capability. Well, Miss Sandrini says that both parents are equally capable and that the boys have the same relationship with both. So that doesn't feature in terms of the strength or the weight that should be attached to wishes and feelings. And the risk, although my Lord has pointed out that he mentions risk in all different places, he doesn't go through the exercise of what if we do what Miss Sandrini is saying we should do, and what if we do what Dr. Friedman is saying. So where he starts from is Dr. Friedman and the point that we got to, which was supervision removed in 3 months if there's psychotherapy, but thereafter Miss Sandrini saying development of contact with this independent monitoring, and Dr. Friedman agreeing with that.
Well, he does address the risk of following Ms. Sandrini's approach at the bottom of 53, doesn't he?
The bottom of paragraph 53?
Yes, the last sentence.
Maybe that's what he's referring to.
What else is it referring to?
Well, giving it a try, I'm not sure. The giving it a try is what the father was asking for. Your Lordship is right.
Doing it with no supervision and no therapy. That's giving it a try.
Well, the father was saying he would do psychotherapy, just not for narcissistic personality traits. But it is removing supervision, yes, and removing all of the supervision immediately was what.
Really, your argument comes out of this: the judge should have the judge should have discounted Dr. Friedman and should have given much more weight to Ms. Sandrini. But what he in fact did was navigate a course between the two. And how can this court remake the judge's analysis?
Well, my lord, if he had done our first ground of appeal was about his analysis of the risk, and what we say is that if he had gone through that exercise that I think both sides agree should be done, but what is the risk of trying it and see? First of all, what's the risk? The risk is that he will lose his temper as he used to do when they were living together. But what's the possible harm that will come from that risk? He will shout, the boys will be frightened. Looking at all of the evidence, what's the likelihood that that risk will materialize? Well, the child expert says there's no risk. That's what she says in the meeting with Dr. Friedman. There isn't a risk any more than another parent with boisterous boys. If the judge had engaged with the issue of what's the risk and what's the likelihood that that risk is going to materialize.
Well, the risks are considered in paragraph 52, aren't they?
My lord, that doesn't go into what the consequences and what the likelihood of any of those risks materializing would be, and how likely it is that the risk is going to materialize. That's the if he had engaged with how likely, then he may have come to a different.
You do need to look at the whole of the judgment. You know, he's doing different bits into different things, and when you get to 58, he says, for example, the dropping supervision of weekday contact to occur immediately. The risks are modest, the boys wish it, and the effect on them is likely to be good overall, and the father's capability suggests we'll manage it. Right, so he deals with, I've set out the risks, now I've set out the other things, and you come back to 58, he says, right, that's what I can do about the weekday contact. And then he goes on to the risks and the effects of change for full-day contact. So one does have to look at the judgment as a whole, doesn't one?
Well, and the extent of the risk is covered in 47, where he says the judge concludes he is a significant risk, but not to the extent that Dr. Freeman identifies.
Yes, but a risk of what? Of shouting? And is that a reasonable, from the evidence and from Miss Sandrini's comprehensive assessment, she says there's no risk. And if she's wrong about that, then the judge should have engaged with why she was wrong about that. She was the single joint expert dealing with what should happen next. And what the judge did was completely different to what she was advising the court to do. And when a judge decides to reject an expert in that way, then it would be proper and appropriate for him to explain why it is that she's wrong about that. What Mr. Justice Williams does is that he approaches it in a really general way, and he says that Miss Sandrini didn't really accept his findings of fact, and therefore he treats her evidence with great caution. Now, there is very little Miss Sandrini could have done more than she did, which was to say she took the fact-finding judgment as the basis, but then she said to the court, she said she confirmed that in the experts meeting. She took that as the basis, but then when she was asked about it in court, she said that she had to test the father on each of the findings because he didn't accept the findings, and he had said that to her. So she had to test them, and she explained that to the court. She engaged with the father to see what he was saying about the fact-finding, because she had to do it as part of her assessment of the risk that he would create for the boys going forward. And after doing all of that, she came to the conclusion that there wasn't a risk any more than the normal from her global assessment. So if the judge was disagreeing with that, which he clearly was, because he came up with a totally different outcome, he rejecting the expert, which he's entitled to do, he decides the case, but he should have explained why he did that.
He uses that at 31 to 33, and he says there were two things that he took into account. One, Miss Sandrini hadn't realised that even though there was no diagnosis of personality disorder. There was a diagnosis. That's the first thing. And then further on at 32, he says she hadn't realised the importance of the fact-finding judgment. And he looks at that, and then he gives his conclusions to the weight that he's going to give on to Mrs. Sandrini's evidence of 33. And the overall effect is it's valuable information about the current situation of the family, some insight into the father's parenting, and a useful application of the welfare checklist. So he says that's what I find about your evidence, and those are the two reasons why. And then at 47, he does say he's putting that together with the other things, the Friedman report and other things, and then he goes on and does the analysis that he does from 47 onwards.
Yes, and it's back to the weight that he attributes. First of all, the fact-finding judgment, she confirmed time and again that she used it as her base. So the judge would have to say that he disbelieved her when she said that, because she said it in writing, etc. For her to lose the amount of influence that one would have expected the only child expert to have with the judge, there needed to be engagement with why it was being rejected, other than saying that she didn't accept the fact-finding. As an expert, she said she did accept it, but she explained she had to engage with the father, as I've just said. But as far as her evidence is concerned, it was current, and it was global, and it was holistic. But Mr. Justice Williams didn't accept it for the two reasons my Lord has just given, and we say that was an unjustified rejection or a downgrading of her evidence that simply wasn't justified on the evidence, because he did accept, we set out in our skeleton argument, all of the factors that he appears to accept from her in terms of the welfare checklist. And he says in his own analysis of the welfare checklist, which we were on a second ago.
Forgive me, Ms. Sandrini gave oral evidence. Again, this is a judge who saw the witness give evidence and has done a very detailed review. I mean, it's just not this court's function to reassess witnesses that we haven't seen that the judge saw give orally. I mean, you're doing it with great persuasion and great charm, but all of these arguments are ones which just don't run in this court. But if you forgive me saying so.
Oh, my Lord, yes.
You understand?
I do understand.
Yes, the uphill path.
Yes, I do. Ultimately, the order that was made was disproportionate.
Yeah, I mean, as I said when I gave permission, on the very limited extent that I gave permission, I think I said in my reasons, the appeal is against the order, and the question seemed to me that I wanted help with at a full hearing, is whether, when you put together everything the independent social worker had discovered through her extensive inquiries and expertise, against the backdrop of the findings with Dr. Freeman, whether the order effectively was too extreme, whether there was given how well contact was going, that the judge was going to allow unsupervised contact immediately, notwithstanding the psychotherapy hadn't started, whether actually it was for too long and too limited.
Yes,
that's the basis that you were given permission.
Yes, well, my lady, when you look at the judgment in terms of the likely effect of change, we say that the evidence justified a very different change to the one that the judge made. And when you look at the welfare evidence at that point and what should happen next, the boys at their age were expressing for many, many months that they wanted more time, that they wanted unsupervised time, that they wanted spontaneous time. The only welfare evidence was from Miss Sandrini saying that contact being supervised in the future was likely to not be helpful to the boys and could be harmful. That was she explained that to Dr. Friedman. She specifically said that she didn't think it had been harmful so far, but that the fact that it might continue for Miss Sandrini was not in the boy's interests. And the purpose of supervision ongoing was not clear. There wasn't justification for it, because on Dr. Friedman's diagnosis, the personality traits that she found to be problematical and diagnosed my client as having as a problem, there was no evidence of them since March 21, and this is now May of 23. So not only is there no evidence of those traits, but there is evidence that he's changed. So to not allow the contact to become, well, firstly, not to make a final order, and secondly, not to let the family, with the final order, let the family get out and do what was a much more constructive exercise, which both experts had agreed should be the way forward. We say that was wrong. It is an ongoing interference with the boys' relationship with their dad, or it was until it stopped. And at a time when the father was saying he would engage with psychotherapy, it was the wrong decision to make for these boys and for the family. So when it came to Miss Sandrini's analysis of why it was time to move on, the judge didn't really explain why he was saying what was the purpose of more expensive supervised contact. And even at the end of the hearing, when the transcript is there of the discussions that followed the hearing, the option of having the nanny who had been picked by mum to supervise contact, that she was, I think, a third of the price of parent help. Even then, Mr. Justice Williams was saying, well, there has to be 1 in 4 has to be professionally supervised. So the cost wasn't justified of ongoing supervision. The interference with the boys' relationship wasn't justified, given where the evidence had reached at that point, which was that there were months and months and months of not problematical interactions between the boys and their dad. And we would say that as a minimum at that stage, there should have been a progression, firstly without court intervention, but secondly along the lines of what the two experts had agreed was right for the boys. Since then, the court now knows that the father has engaged in the psychotherapy. Things have moved on, but the order is wrong. The one night, no more than one night, is even if a child were in interim care in public law proceedings and was being rehabilitated, you wouldn't have the kind of progression that Mr. Justice Williams has ordered. There is no prospect of anything more than one night until maybe autumn of next year, by which time the boys, a lot of their childhood, it's gone and can't be gotten back. So what we are saying is that Miss Sandrini and her progression and the scheme that she was suggesting is what Mr. Justice Williams...
so if you just articulate then, what do you say it should be?
So the scheme that Miss Sandrini suggested, but it starts at 205.
And this was her final position in oral evidence, was it?
No. Her final position would delay. There was a delay of 3 months.
Well, that's not her evidence then.
Anything happened. No. Her evidence.
So your submission now is that we should go reverse back from the evidence she actually gave at the end of the day to evidence she was proposing to give before cross-examination.
No, my lady.
Sorry, I've got lost here then.
I'm sorry, that's my fault. Her scheme is set out there. I'm not sure that it's going to be of use to you. What we have asked for is a rehearing, given that the court is not going to engage with the mechanics of the contact arrangements. Things have moved on so much that it's very difficult to see where this court could go with that.
But
Bearing
what would
in
you
mind,
be asking for at a rehearing?
what would we be asking for?
At a rehearing?
A move from the current regime towards shared care and the system that was suggested by Ms. Sandrini in her report.
But a rehearing would necessarily involve Dr. Freeman again, because that would be the nature of a rehearing.
Well, a fresh hearing, not a rehearing of the same evidence, because clearly, if you saw what Mr. Justice Williams said, if it's to go back to Mr. Justice Williams, he seemed to be saying that he would need a forensic psychiatrist to start again, as it were, to go back to where he was in July 22. Our position was you don't need a forensic psychiatrist. But in the event, at the time of final submissions, now we are saying that there should be a fresh look at the case and a proportionate look, and that it shouldn't be with Mr. Justice Williams, because he has done 2 very long judgments. He has seen these parents twice, but the value of judicial continuity, we say, isn't outweighed by the decision that he made, which, you know, we say is unusually draconian and disproportionate interference with the family, with the family's life. So we say really, and it should never, in my submission, have been a High Court case in the first place. I think it was by accident. It was supposed to be in front of a district judge, and there was a listing issue at Guildford. So that's. No, it's not an accident. Sorry, it's not an accident. Sorry, that's.
There's a lot of people queuing up for hearings in front of High Court judges that would like an accident like that to happen.
Yes, well, quite. It was case managed, I think, by District Judge Hammond. That's my point. And there was nobody to hear a 4-day case. And I think Mr. Justice Williams was not accidentally, but on purpose, on circuit in Guildford, and had a gap in his diary. My point is that this is not a case under the rules that would ever usually be allocated to a High Court judge. That's my point.
You want a fresh hearing before a new judge, but not a High Court judge, a district judge.
A district or circuit judge.
District or circuit.
It's a normal, well, it may not seem normal now, but
No.
It's a straightforward welfare case in terms of what relationship the children should have going forward.
It's quite difficult, though, when there's already been a decision by a High Court judge to be asking it to be remade by a district judge.
My Lord, often, certainly cases that have a reason to be in the High Court go back down to the CFC, for example. Say there is an abduction and the children remain in the country. It's only in front of a High Court judge because of the abduction, and then it goes down to the CFC, DJ or CJ. So
to remake the decision of the High Court judge?
No, it would be...
That's what we're doing here.
It would be a... the decision is there. We're asking for it to be overturned and for a new welfare decision to be made. I would anticipate that the judge would give directions, and you would have the history of the 2 judgments that are there, and whatever judgment happens here, and then you continue. Children Act orders, as you probably know, are never...
Can I just check that?
Final.
Because if you're right, we'll overturn the order. Does the fact-finding judgment stay in place as a fact-finding judgment?
Of course.
Right, so the fact-finding judgment stays in place. And what's the status of the welfare judgment then? Because we've overturned the order, and the order is based on the judgment. So could a new judge safely have regard to that, just so that I understand the machinery?
Have regard to the judgment?
The welfare judgment, the latest one, the one that's under appeal.
Well, my Lord, yes, with any judgment from this court which identifies where the welfare judgment went wrong. So it would be a judgment. We are saying, obviously, on that ground, that the disproportionate interference and the weight of the evidence, etc., means that the order that was made, including to have a review next year, was not the right. It was the wrong order.
How long will it take you to get a welfare hearing in whichever court it's on?
Months.
Months. So what happens in the meantime?
we
Well,
would
they carries
have
on
first.
having his psychotherapy, I presume, and working to.
Yes,
We
to
carry
get
on.
his-
We
to
carry
get
on
his
with
overnight
Miss Justice
stays.
Williams's order.
yes, until.
Well, then it's going to expire, isn't it?
Well, my lord, no, because one would hope to get a first directions hearing at which contact would be considered.
But-
well, it would be remitted to a court other than Mr. Justice Williams. Can we just look at it the other way? If we go to a review hearing with Mr. Justice Williams in May of next year, that's for 1 hour, and then there would be a listing for 3 days, I'm guessing at the end of next year.
Well, they could settle.
Mediation obviously is an option,
They've managed to arbitrate and sort out the money.
or arbitration.
They could
If-
perhaps look
yes.
at mediation or arbitration.
The children.
Yes,
I
because
mean, they're so close now to a resolution for the children, you know.
well,
Anyway, you say that
Just-
if we go as long as we are, we'll have the 1 hour hearing in May, and you say it's unlikely that you'd have a 3-day welfare hearing until autumn of next year. So what you are seeking now is to set aside the order and to say that the welfare judgment can't be relied upon, or the paragraphs in the order for which you have permission can't be relied on because this judgment is flawed in the ways that you said. So what's going to happen next? There's going to be a directions hearing before an appropriate judge who will decide whether or not to have a different joint instructed expert, because if there's findings of fact about possible psychological problems explaining the behaviour, you're going to have psychiatric evidence of some sort, aren't you?
well, my lord, possibly a Part 25 psychiatric assessment, but the autumn guess is if it's in front of Mr. Justice Williams, there won't be a substantial hearing.
No, I understand that. That's why I'm asking you not to focus on that. I went through that.
Yes.
I'm now trying to understand in my own mind, just so that I understand it.
So, my lord,
What's
what
going to
would-
happen at the directions hearing before the new non-High Court judge? It's going to be directions for expert evidence.
Yes, for. I imagine that the position would be. We obviously haven't discussed directions because that's.
There'll be
not
directions
a
hearing
conversation we've
first.
been having. There would be a directions hearing at which point the court would be able to consider the issue of interim contact in light of the judgment of this court together with the previous 2 judgments, although obviously the 2 parts of the order, when we look at the parts of the order that Her Ladyship has given permission to appeal on, the parts of the order that we say should be discharged are paragraph 9, C, D, and E.
So that the father no longer has an obligation to continue with his psychotherapy, so he can stop.
Yes, although he is, I'm sure, would be willing to give an undertaking to continue with that, because that is
Just-
something that
just
he
help
was
me with the
willing to do
technicalities.
anyway.
Just to help me with the technicalities, because the father very wisely has thought, right, this order is, although permission to appeal has been given, you know, time's marching on, I'm going to do it. I'll just do it and see where I get to, and I may even get that I'm nearly at overnight stays. If the good doctor the other good doctor had not wanted a nice long summer holiday. Right. Now, if I set aside this order, then the mother and the father no longer have an order, and so the mother is under no obligation to allow matters to progress as set out in that order, and the father is under no obligation anymore to continue with psychotherapy. And your plan would be to go in front of a CJ. I think most DJs would be getting rid of this as fast as they could if it landed on their desk. And you'd be asking a circuit judge, make an interim contact order, because now we're in no man's land.
Well, my lady, firstly, as a pragmatic point, if either my client stopped going to psychotherapy or the mother didn't agree to overnight contact starting, that no doubt would influence a judge in due course. I am sure that my instructions would be that my client would give an undertaking to continue to do the psychotherapy. It may be that Mr. Verdon's client would agree that the overnight contact could commence. But the point is that the order shouldn't remain in place if it is disproportionate.
I understand. I'm just trying to work through in my mind what
Yes,
precisely what orders would work and what wouldn't work in the event that your appeal succeeded.
Well, of course, my lady could substitute an interim arrangement,
Of course,
which
could be in identical terms pending
exactly,
a directions hearing.
Exactly. That's an obvious answer. Is to replicate it in a new order, but we say really that overnight contact is long overdue. That the father has, as your ladyship has said, been pragmatic and done what he needs to do, and there's even more evidence that it's time to move on, as it was.
I don't think father or you would expect us to introduce overnight contact off the back of the appeal without further evidence.
Yes, as I say, the obvious answer is to replicate the 26 weeks, updating it to the date that I gave earlier, that I the 7th of January. Thank you.
Thank you. Now,
and the other, just for the completeness, the other orders, obviously the holiday part under paragraph 10, C and D.
Yep. Thank you.
And my lady, you also stayed the paragraph 22, that I think has reached agreement in any event. The parents have agreed a narrative that can be sent to the school and could be sent to the school.
Thank you. Thank you.
My lady, can I just double check?
Of course.
There isn't anything significant? Thank you.
Anything else? Anything else? No, thank you very much indeed, Ms. Kirby.
My lady, my lord, inevitably this appeal has moved forward during the course of the morning, and perhaps with your permission I'll look at where we're going in light of those recent exchanges, and with respect to remind my lady that you dismiss the appeal which has reserved this case to Mr. Justice Williams, paragraph 24, and listed a review in May 2024. So unless my lady changes her view on that issue, it is going back to Mr. Justice Williams. And unless my lady's been persuaded by the argument from Ms. Kirby just recently that actually it should go in front of a district judge because the judgment was so flawed that Mr. Justice Williams cannot be trusted to take into account the Court of Appeal's indication on any specific points that you think were wrong, then it is going back to Mr. Justice Williams, and in May, unless this court directs it should be considered earlier. I should say also at the outset that only during the course of the oral hearing and only a few moments ago was it clear to those on this side of the court what the father's actually seeking. And it's only now that we learn he's actually seeking a rehearing, and the court, with respect, have explored with Miss Kirby what that would look like, when it would happen, who would have to give evidence, and the delay it would cause. And that obviously runs completely contrary to a fundamental criticism of Mr. Justice Williams' decision that in fact this case should be reviewed by him because he knows the case best, rather than left to these two parents who are in high conflict to try and resolve with a third party, which was the point and the submission being made by Ms. Kirby not 10 minutes before that other point. So on the father's current case as put, we're locked in litigation, costly litigation, for months and months and months and months at huge expense, which expenses completely dwarf the cost of therapy. It's a question of priorities, we would say. May I deal with some general points, having said that by way of introduction, general points in relation to this case and general points in relation to legal principles before turning to where we are now and the actual grounds of appeal. At the risk of stating the obvious, this particular judge, Mr. Justice Williams, knows this case extremely well, having been in charge of it since the fact-finding hearing, throughout the welfare hearing, and has seen the parties give evidence twice at some length. And whereas this court has a mass of material, it certainly doesn't have all the material that Mr. Justice Williams had, all the source material, the statements of evidence, etc. And nor does this court have, the appellant has chosen not to put this before this court, the extensive cross-examination of the two experts. So you have an experts meeting transcript and you have their written reports, but you don't have their oral evidence, albeit we say Mr. Justice Williams summarised it accurately. But the net effect of the oral evidence of the two experts, I would submit, and Miss Kirby may or may not agree, that she, with respect to her, made very little progress in cross-examining Dr. Friedman on the issue of the diagnosis, which we say the father was obsessed with at the lower hearing, and it clearly remains a great concern of his. And again, without sounding boastful, we made more progress in the cross-examination of Miss Sandrini, for very good reason, which we set out in our skeleton argument. And we say Mr. Justice Williams was fully entitled, having heard the oral evidence of the two experts, to reach a view as to their opinion, to agree with them or not agree with them, which he did, and as has been mentioned many times this morning, to chart a route between the two positions. And we fundamentally disagree with the characterization of Ms. Kirby that the doctor got a gold star and the social worker was dismissed. It was much more nuanced than that, as a transcript of their oral evidence would show.
Well, you're saying it's a classic case of island hopping.
Forgive me, my lord, I am.
No,
No, sorry.
Or
Miss Kirby is,
Miss Kirby is.
engaged in island hopping.
She is island hopping, my lord, and she's seeking, with respect to her, to re-argue the case. A second som offensive, she won't mind me saying this, it's a term that my lord used in the lower court. She robustly cross-examined the social worker, focusing on this issue, which clearly perturbed her client, focusing on the label. And in fact, Mr. Justice Williams, in answer to my lord's point, deals specifically with this, no doubt anticipating that it may be a problem, because the father, to be fair to him, said in the lower court that he would appeal an outcome he didn't like. And that's why my lord said at paragraph 39, he seeks an outcome on his own terms. But anticipating this potential issue, my lord Mr. Justice Williams, at paragraph 23 of his judgment, deals very clearly with the issue of label. And perhaps it's worth looking firstly at paragraph 22 of the judgment, 96, page 96, where Mr. Justice Williams deals head-on with Miss Kirby's critique of methodology and says what he says, and I won't read it out loud, but it's there, clear, and probably summarized in the first sentence. Too formulaic, too narrow a textual analysis, ignores the totality of the evidence, and then I'm going to jump over the rest of paragraph 22, but he deals with this very issue there. And then at paragraph 23, he says this, which we say cannot be a wrong conclusion. I do not think the focusing on labels is of much assistance and tends to detract from the substance of the concern, as was clearly evident in the cross-examination and the father's own evidence. And again, the judge anticipating where we are at now, which is the second offensive, focusing on the word narcissism generates a great deal of heat. What my lord was saying far more eloquently than I can say now in those two paragraphs was that forget about the label. The issue was the father's behaviour and whether it was problematic for his sons in the current situation. and that links to the issue of risk, and Mr. Justice Williams, we say, dealt with that fully and squarely in his judgment. I've made the point that he knows the case extremely well. This court, we say, and we fully appreciate, of course, that permission was given on a very limited basis, but we say this court now needs to look at the current situation. And the current situation is very different to that which it may have appeared to my lady in August, because this father is having 3 unsupervised contacts a week. In other words, almost every other day. It's not an alternative fortnightly pattern. 3 times a week, in term and in holiday, unless the mother's abroad.
So that's the Wednesday
In term, it's Tuesday, Thursday,
and
and
Sunday.
one day of the weekend, Sunday. And then in the holiday, it's slightly different. I think it's Thursday, Friday, Saturday. So it's 3 times a week. And we say...
And Sundays all day. I mean...
And any day
Most
when
of
they're not at school all day, 10 till 6, I think it is. So we say, in the context of a case where there were extensive findings about the father's behaviour, regardless of the label that we put on the father's behaviour, the findings are there, they're not appealed. The learned judge made more findings in the welfare judgment, again, which are not appealed. The judge was fully entitled to chart a route map going forwards over a period of months by which the contact, the time the father spent with the children, gradually increased. Stage 1, immediate non-supervision of after school. Stage 2, non-supervision on the weekend and non-supervision in the holiday. And there's a half-term holiday coming up that will be non-supervised. Quicker if the father has therapy. The carrot and stick approach, which is used by family judges up and down the country to try and encourage parents to engage with the most effective intervention. A word about therapy. Not only was it Dr. Friedman who recommended therapy, very intensive therapy over a long period of time. We say that's quite a conventional recommendation made by an expert in the family justice system, because the conventional wisdom is that therapy takes a while to take effect. Not only that, but Dr. Opedick in 2018, on the father's account to him of what the problems were, also recommended exactly the same type of intervention, psychotherapy. And the difficulty the father has with that evidence is that he still maintains that what he said to Dr. Opedick wasn't true, and the judge did not accept that evidence. Therefore, if it was true, Dr. Opedick was fully entitled, on the basis of what the father himself was telling him about his problems, again, regardless of labels, and there may be a slightly different label between what Dr. Opedick thought the problem was and what Dr. Friedman some years later thought the problem was, but there's also a lot of overlap between the traits. Dr. Opedick in 2018 was saying therapy. Dr. Friedman in court proceedings jointly instructed was saying therapy, and in fact Ms. Sandrini changed her position and also agreed therapy for stage 1. So there was a consensus of professional opinion that that is what he needed, and this court now knows he has engaged with it. It's not as intensive as recommended by Dr. Friedman. It's once a week, we understand, but he has identified, we were told recently, an appropriate expert who has sent us an email to say he's engaged and he's attending. And that order, we say, that he should have therapy, we say cannot be said to be wrong, given that overwhelming professional evidence. And so what are the next stages? Well, the next stage is as soon as January, because the father is engaging, and Ms. Kirby tells us he will continue to engage, the next stage is in January, test overnight contact by allowing, in the first instance, 1 overnight contact, both in term time, every week, not alternate weekends, every week, and also in holidays. And then, only 4 months later, in May, review the situation. And the mother isn't appealing the order. She will comply, as she always has done, with the provisions of the court. And so we can anticipate that if the father continues to engage in therapy, and Ms. Kirby says he will, although for a reason I don't understand he'd prefer to give an undertaking to do that. But in any event, he will continue to engage, he says that to this court, and therefore you know that in the foreseeable future, quite soon, there will be overnights. And Mr. Justice Williams will be in a position next spring, in May, to see how those overnights have gone. And then the narrow focus of the dispute in front of the judge who knows this case more than anyone and knew about all the evidence that was given will be, how can those overnights develop? And what should be the ultimate pattern? Given that my lady has said, at the permission hearing, the appeal against the lives with order is not permitted. And so the father needs to understand at this hearing that that is no longer a sustainable objective. It is not going to be equal shared care, but it doesn't reveal anything on behalf of the mother's case to state the issue will be quantum of overnights. Once overnights are established, and assuming they go well enough, I say that advisedly, because I'm not going to trouble, of course, I'm not permitted to, this court with ongoing problems that are happening on the ground, which no doubt the court will need to look at in the future. But assuming things go relatively well, the issue will be, how can we develop overnights? And that is something which the judge is best placed to consider, and will consider it in May, there having been 4 months of overnights. And then he'll consider how to progress that. Consecutive, how many consecutive, and with the greatest of respect to Mr. Justice Williams, that's a matter he can deal with shortly and quickly, because the judgments have been given, the oral evidence has been given, and it'll be a case of making a decision based on submissions. And Ms. Kirby and I'm sure, would agree that to date, Mr. Justice Williams has not been shy of robust case management, and if he considers he can deal with that issue of quantum at the hearing in May, which I don't think actually has been fixed yet, and I wasn't sure if it was 1 hour, but if he thinks he can consider that in May on submissions, he will. He's a High Court judge, and he will feel completely confident to do that. And we are not certainly saying at this stage that there would be a need for further evidence from the ISW or the doctor on the issue of how many overnights, because all of that has been decided, and then it's a question of further progression. So we say that is where this case is going as things stand. I was, my lady, going to make a number of points in relation to general legal principles that apply on appeals. They're all very well known to this court, but the only one I will reiterate, which is an obvious one to make, and forgive me for it, is that, of course, in a case involving the welfare of a child, there's no perfect solution. And, of course, a different court might have progressed the arrangements more quickly. A different court might have followed Dr. Friedman exactly, and therefore more slowly. But this experienced High Court judge, in fact, wove away between the evidence, the opinions of the two experts, having heard what they said and having seen how each of them moved from their original positions through the experts' meeting to what they actually said in oral evidence. And we say, of course, not only are the judgments, both of them, sound, detailed and extensive, but we say they can't be criticised. The only finding that Ms. Kirby focuses on is the paragraph 30 finding. We say that is a sound, solid finding based on the psychiatric evidence the judge had, particularly when you qualify it with paragraph 22 and 23. So we say this court should not replace its view of his assessment of the two experts, particularly when you don't know what they said in oral evidence, and particularly given the detail which Mr. Justice Williams went to in his judgment when explaining why he chose to disagree with Miss Sandrini and how he disagreed with the doctor. And may I just remind this court of what he said in relation to Miss Sandrini, because it suggested that he was not justified in not following her welfare opinion. We say, on the contrary, given her oral evidence, and it starts at paragraph 31 of the judgment, page 104, and it runs through in quite some detail through a number of Roman numeral paragraphs through to 103, 104, forgive me, and 105. The key aspects of Miss Sandrini's evidence, and Ms. Kirby doesn't say that he's wrong to summarise her evidence in that way, and we say he was fully justified in not following her whole scale. A, because she misunderstood the findings despite her protestations in oral evidence. It's clear from the judgment that the judge was not satisfied that she had taken on board fully his very serious concerns. I'm looking at Roman numeral 3, and the learned judge deals with that in some detail, that he was concerned that she wasn't as neutral as perhaps she should have been, because she was critical of the mother for not identifying risks when the risks were clear from the fact-finding judgment, and she was too accepting of the father's explanations. And secondly, and importantly, the point touched on by Miss Kirby, she misunderstood the doctor's diagnosis. And ultimately, when one looks at the transcript of the experts' meeting, it's completely clear that once it was explained to her, she deferred to the doctor, as she had to, on the issue of diagnosis and also treatment, although she questioned the doctor in relation to why that treatment needed to last so long. I would respectfully submit the doctor actually is best placed to give a view as to how long it should last, but ultimately the judge is fully entitled not to go along with that recommendation, and he didn't. His programme is less than half the length of Dr. Friedman's. And so again, he tried to chart a way through this, taking into account all the factors as he should. We reject the criticism of Dr. Friedman that she didn't take into account everything, although we accept that on the issue of the diagnosis, she relied on her clinical interviews, the fact-finding judgment, and Dr. Opdyke's strikingly similar opinion. It's obvious from her report, and I think it's at page 133 of her report, it's obvious that she painstakingly went through all the contact reports. And had you seen a transcript of the oral evidence, you would know that she was cross-examined uphill and down dale about all the contra features of the case, as Miss Kirby has attempted to do this morning in front of you. So you can be satisfied that Dr. Friedman did have the full picture, did read all the evidence, knew about the positive contact reports, but remained of the opinion that her diagnosis in relation to trace was sound. And I repeat, even if her diagnosis was wrong, and that can't be established in this court, even if her diagnosis was wrong, the behaviours are as found by the judge, and the best intervention is as recommended by all the professionals, therapy. So we say, with respect to Ms. Kirby's attempts this morning, the father cannot begin to establish a case that Mr. Justice Williams' assessment of the two experts and conclusions in relation to the way forward based on their opinions was wrong. All the arguments, again with respect to Ms. Kirby, that have been run this morning were run before the judge. He knew exactly the points the father was taking, and he allowed those points to be put, and they were put. And the judgment that he has come up with is careful, detailed, staged, and we're in a different position now to that which we were in August. I'm very conscious of the fact that at the moment I haven't dealt in detail with the specific grounds, but they are fully dealt with in the skeleton argument. And unless you wish me to repeat any of the points there, I wasn't intending to. We say if you trace through the words risk and harm throughout both judgments, there are so many references to it, it was obvious that the judge knew what the risk was, and the risk he summarised, I think, at the end of his fact-finding judgment. It's helpfully put there. losing temper in a familial situation where you're not being watched, not only shouting and screaming and frightening children, but also grabbing and pulling them. That's what this case is about. And the judge knew that. And with respect to the appellants, we didn't need actually a schedule in this case. I know that's best practice, but we didn't need one, and no one until the appeal has suggested we needed a schedule. And there were numerous points to clarify whether the findings were clear or unclear. Everyone knew what the findings were. And the experts, apart from the Dr. Obadick point and Dr. Friedman misunderstanding what the judge found, the experts had the documentation, and it was in fact Eleanor Sandrini who did not take them seriously enough, but they were clear. So, unless I can assist further in relation to the specific grounds, I'm conscious of the fact that I have not spoken at great length, but unless I can address the court further, we say it was a proportionate outcome and not a draconian decision, and we say the judge was fully entitled to take into account the opinions he had, and if you look at his judgment, clearly took into account all the other factors, including the boy's wishes and feelings, and we say his paragraph, which this court's been referred to, is a sophisticated and a nuanced conclusion when you have children under the age of 9 who can't appreciate the risk and don't understand the full history. The judge was fully aware of what they wanted. May I just pause for one moment, my lady, my lords, and just check if there's anything I need to say further. Thank you, my lady.
Could I ask you one thing about the order?
Yes,
Page 74 of Core Bundle. There was a long stop date at 9D, which is 9 months, 18th of February. And that kicks in even if the father doesn't engage in psychotherapy. The 9A2 becomes unsupervised. What I wonder is, next point, there is no requirement as to how often he has to attend a psychotherapist. So my question is this: why doesn't the total period of 28 weeks relate to the period over which he has been engaging with a psychotherapist? And why would you discount from that any period in which the psychotherapist is away?
I think, and I'll check the paragraph number, I think my lord dealt with this in his judgment and talked about 12 weeks therapy, not the passage of 12 weeks.
Yes, but if you attend therapy over a period of 12 weeks, and the therapist says, well, you only need to come every other week, then you've done 12 weeks therapy.
So, my lord, to be clear, we're not suggesting that the father should be attending twice weekly as per Dr. Friedman's opinion. We accept that he has chosen an appropriate expert, and it seems from the very short email we have that it's weekly attendance. And we're not taking any point in relation to that, but I accept my lord's point that Mr. Justice Williams did not, in the order, specify that it had to be weekly or 2 weekly. But we say what he meant.
My point is simply this.
Sorry.
If you take into account the weeks that a psychotherapist may be away, it may be that the therapy will extend to the 24th of February. So 18th of February, or very close to it. I'm just wondering why it is that if the father's attended over a 26-week period and engaged in that 26-week period, even though he didn't attend every week, why 9C shouldn't kick in in December?
I'll answer, my lord, in a way I hope is helpful. Of all the disputes between us, we're not in dispute that according to this quite complicated order, in fact, the provision kicks in. My learned friend said the 7th of January. We thought maybe the 15th of January.
Well, I'm just suggesting to you, I'm not sure that is necessarily the right reading of the order.
Well, that would be subject to how many therapy sessions are missed at the Christmas holiday, which I accept is a valid point, that would mean that either there have been 12 weeks of therapy itself or 26 weeks of therapy itself, excluding the delay to it starting and excluding the holiday time that the psychiatrist took.
Well, the order does say attending and engaging with them for
That's
a
where it
total
was.
period of 26 weeks.
Thank you.
So he's not had the opportunity of attending, no doubt he would have done,
Thank you.
but he wasn't able to attend during the periods of time when he was the
That's where it was.
therapist
But
on
forgive me,
holiday.
the answer to that is it doesn't say you have to attend weekly.
No, but the father is.
Yes. Well, I know, but we're dealing with construing the order, aren't we?
I
Anyway,
suppose
maybe if neither party wants to take the point, but it just seemed to me that to have this stretching on into February would be
it will now be
January,
January, my
January
lord.
the 7th.
But that's assuming that the therapist doesn't take another 5 weeks off over Christmas.
Well, we don't know anything about that. I don't think that inquiry has been made.
You'd be pretty sure that the therapist will take 2 weeks off over Christmas,
Perhaps.
which will take it into close to February.
Well, then it'll push it to nearer
Anyway,
the
I'm
end of
just.
January.
It
My
just
lord,
seems
it's
to me
not a-
that seems to me maybe something which isn't necessary given the order. But
My lord, all I can say really is, firstly, we agree as to when the provision kicks in. Two, it seems, despite the father's overall position, that he understands that the spirit of the decision was intensive therapy, which Dr. Friedman said was twice weekly, but he is implementing weekly, which point we're not taking, certainly in this court or in the lower court at a future hearing.
And it may be the total period hasn't to be consecutive. It could be if the therapist is there for 30 weeks, but he's missing 4, the 26 will be the first number of weeks and the last number of weeks with a break in the middle. That may be what the intention was.
Unsurprisingly, this court is looking at matters in even more precise detail than we have been able to. We're not taking a point in relation to consecutive weekly attendance.
Any questions?
No.
Any other questions? Thank you very much for calling. Yes, Ms. Kirby, anything in reply?
Briefly, my lady, I presume you'd like to
How long are you intending to be in reply?
10 minutes max.
Do you have any meetings?
No, nothing, no.
oh, sorry.
Will it cause massive inconvenience to any of the parties if we finish? If we carry on for another 10 minutes? No? Right, let's do that. We should be grateful to my Lord Justice Phillips, who's the one that's inconvenienced amongst of all.
My lady, I'll be brief. Points of emphasis that I think my client would want to make in response to Mr. Verdon. The first is that when referring to to my client's behaviour, the behaviour that has been the subject of the judge's findings, I'm sure my client would want me to emphasise finished by March 21, apart from, as my lord pointed out, his presentation in the witness box in July 22. So when talking about this order, the behaviour in question was quite old, taking, as we do, the fact finding as the background facts. So it was his historic behaviour that was the subject of the judge's was the arena that we say the judge was emphasising in an inappropriate way when he made the order that he did in May of this year, because by then it was 2 years, 3 months since there was evidence of my client misbehaving in a way that was adversely affecting the children. And since then, all of the evidence is that he hasn't behaved in that way. And because all of the evidence is of that, it was a disproportionate order that was made. The children's lives, it's a quarter of their lives that they've had supervised contact for by the time it finished. And that is highly unusual, as my lady knows, even where children have been put in care as a result of physical, emotional, etc. abuse. the rehabilitation through supervised contact is usually a matter of weeks
It's a very
into 3 or 4 months.
situation. It's a very different situation. I take your point that it's a lengthy period of supervision, but I don't think a comparison to a rehabilitation programme, which is usually dealt with quite quickly for all sorts of different welfare.
Yes, or take a private law case where there is a period of supervision, just as Mr. Stroud pointed out. By the time November 21 came round, he was saying supervision,
And
we
I
really
take
need to keep a watching brief on it. The pace of change is highly unusual. To say that there should be highly unusual in light of the evidence, but in any event, usually these child arrangements orders have at least weekend contact, and here there is a single overnight for a period. Mr. Verdon makes it seem as though it's going to come around quickly for the children and for my client, and for them, when they've been asking since November 21 to have overnights, it can't be said that just waiting until January is a small thing for them, because January 2024 is a long way for a little boy from November 21 when he first asked for overnight contact. The therapy that my client has undertaken, it's not been by agreement that it's been the 12 weeks of actual therapy that the mother has insisted. I'm instructed that it was 12 weeks of actual therapy, taking out the period that the therapist was on holiday. On the point of the label that was given to my client, you will have gathered that it is of huge importance and significance to him. The label of narcissistic personality traits has been the focus of the first instance and of the appeal. Mr. Justice Williams says that labels aren't important and unhelpful, I think he says, in his judgment. But the label is the diagnosis. And that was why the court went to Dr. Friedman, and therefore it is important. It is important to the judge, and it is, we say, as you know, a mislabeling, and I won't go back over that point. As far as the idea that we can expect, as Mr. Verdon suggests, that we go to a 1-hour hearing in May or thereafter, if it hasn't been fixed. I thought it had been. If it hasn't been fixed, then we'll be further into the summer. But the idea that anything would be agreed is not predicted. It's not predictable, it's not foreseeable given the history of these proceedings. At the pre-hearing review, the mother didn't want a Section 7 report because she wanted to rely only on Dr. Friedman's evidence. And that was a contested direction to even get independent evidence about what was good for the children. And her position at the final hearing this time was that supervision should continue indefinitely, or as per Dr. Friedman's original recommendation. So it is not foreseeable or in any way predictable that a 1-hour hearing in the summer of 2024 will lead to an agreement. I'm afraid that is not this case. And rather, if Mr. Justice Williams has position statements from each parties, Mr. Verdon has already explained that he has instructions about difficulties. Of course, there are ongoing difficulties. They haven't disappeared. They are unlikely to disappear absent the recommendation of the experts being followed. So the idea that we will get progress at a hearing in the summer is in my submission, based on the history of this case, fanciful and not realistic. And therefore, realistically, we are looking at winter before Mr. Justice Williams has the material that he needs to make a decision, and he is not the kind of judge that's going to do anything on the hoof. So we are facing, if we wait for Mr. Justice Williams, a very long wait before an imposed judicial decision. A couple of other points. As far as Dr. Opajic is concerned, Mr. Verdon says in writing and to you that his report is strikingly similar The only similarities are that anxiety is a feature for my client in both reports, and that a personality trait is identified by each of them. But they're totally different traits that are identified, and we say that there is no way you can say that there is strikingly similar. The diagnoses are strikingly different. The other point about that Mr. Verdon made about the contact notes is that, yes, they are set out at the back of Dr. Friedman's report, and we looked at them. But what is totally absent, it's as if somebody else did that part, because there is no mention of those contact notes in the analysis of Dr. Friedman and in coming to her diagnosis. Absolutely no mention of them. And as I submitted earlier, one would have expected, with evidence as relevant as that to behaviour over a very long period of time, and behaviour with the children when she chose not to do what she'd been asked to do and see the father with the children, should have, in my submission, played some part in her analysis and diagnosis or labelling of my client. The other point that I should raise is about the lack of a summary of the findings at the fact-finding stage. The practice direction 12J provides that at the end of a fact-finding there should be a schedule of what findings have been made. And the difficulties that arise when a court doesn't do that are illustrated very well in this case. Because you will have seen, and I apologise that it was late arriving, that Mrs. Justice Knowles' decision in Re P was sent as an example of what we are submitting the lower courts really need, which is emphasis on paragraph 29 of Practice Direction 12J, to say that no matter how complicated, in that case Mrs. Justice Knowles heard evidence over many, many days on a very complex High Court case and made findings against each of the parents and put them down on one page on the back of the judgment. And in my submission, if this court were to say that that was a very good idea, then that would be very helpful in terms of what courts should now be doing after H&N, because the practice direction is clear, it should be done. I haven't seen it done, don't know whether Mr. Verdon has seen it done, but after exhausting fact-finding hearings that are taking a huge amount of time to get through, the fact that you can have misunderstandings like Dr. Friedman had about what the judge found could be avoided if there was that one page. I know it's a lot of effort, so are the fact-finding hearings, and it would be incredibly useful for judges that aren't continuing from the fact-finding, and for practitioners, and indeed for parents and experts, to know that these are the findings. And even in a very complicated case like Mrs. Justice Knowles conducted in Re P, it was incredibly helpful to have at the back of that judgment a one-page summary of the findings that were made. Could I just check that I haven't left anything out? No, thank you, my lady.
Thank you very much. We're just going to rise for 5 minutes. Please don't go away.
Something short, a small miracle.
Sure, yeah, I'll stay.
Think you know. Right. It's amazing that I can talk. When we get out there, I'm going to start.
Ms Kirby, Mr Burden, we're not going to give a judgment now. We are going to reserve our reasons. But we've been very conscious of the overall dynamics of this case. I'm so sorry the mother's not back in court. Do come in. No, don't worry. Forgive me. I hadn't noticed that you'd not got back. Come and sit down. I was simply saying that I'm not going to give any, none of us are going to give any reasons at this stage, but given the dynamics of the case and the state of contact as it is going at the moment and progressing at the moment, we've decided that the appropriate thing is to give you the outcome and our decision whilst reserving our judgment and our reasons. Therefore, we'll tell you all now that the appeal will be dismissed. And that means that the order of Mr Justice Williams will remain in force, and the excellent progress that has been made up until now, which has meant that supervision contact is no longer supervised and will work towards overnight contact, hopefully in January of next year. And we'll aim to get our reasons out as soon as possible, but that allows all the parties to aim to get a hearing date for the directions hearing. We'll send out our judgment in draft in the normal way for typographical and any factual infelicities, not an opportunity to re-argue the case. And I'd hope that any other outstanding matters can be dealt with in writing. If there's any difficulties between you, we'll have written submissions about it, please. Is there anything else that you need us to deal with either? Ms. No?
Thank you.
No, thank you, my lady.
No, thank you all very much, and thank you for sitting over the shorter chair.